Hello, my name is Benjamin Hart. I'm an American attorney and Managing Director of Integrity Legal here in Bangkok, Thailand. In this video, we're going to discuss the SB-1 returning resident visa. In another video on this channel, we discuss presumption of abandonment of U.S. lawful permanent residence. I recommend that those who are watching this video probably would be a good idea to watch that video in tandem with this one, as there are themes that will overlap, and it'll get a better idea for those who are looking at an SB-1 returning resident visa. It'll give some context on how this comes up. Basically, what happens with respect to a returning resident visa is one gets oneself into a position where the presumption of abandonment of residence could be raised, has been raised, it's come up. Basically, what we're talking about here is someone who is a green card holder in the United States who spent a significant period of time outside the United States, or under some circumstances where their green card or I-551 temporary green card stamp has essentially expired while that individual is abroad, and that individual does not have what's called a re-entry permit in order to get back in the United States. A re-entry permit can mitigate this problem because the re-entry permit itself could, in theory, be issued out past the validity of, say, an underlying green card or something, and for that reason, that re-entry permit could stand alone as evidence of residence in the United States, lawful permanent residence in the United States. There's another video on this channel regarding re-entry permits. It's actually discussed both in the context of U.S. re-entry permits and Thai re-entry permits. I recommend those who are interested in this topic perhaps check out that video as well regarding re-entry permits. But okay, let's say somebody is abroad. They've been abroad for, let's call it 24 months without having returned to the United States, and let's add one more factor into this sort of hypothetical. That individual's green card has also expired while they're abroad. What can that individual do? Well, it depends on the underlying circumstances, but an SB-1 returning resident visa may be a remedy to this overall issue. Having the green card expired and having been gone for so long, again, there's the possibility of the presumption of abandonment of residence at U.S. Customs and Border Protection being raised. Also, it might be impossible to even get on a plane because the green card has expired, and certain aviation regulations would prohibit allowing a person to even travel to the United States, not prohibit the person, but prohibit the airline through various sanctions that can occur as a result of them bringing that person to the United States. So we've got this situation, but let's say, for example, an individual's family member fell horribly ill, or the individual themselves fell horribly ill overseas and just simply couldn't make it back to the United States in sort of a timely manner. One can actually file for an SB-1 visa with an embassy that has consular jurisdiction over the individual or over the territory at issue. That being said, an SB-1 visa, it's kind of an interesting thing. Maybe interesting is the wrong word. It's something of an obtuse travel document insofar as it's not routinely processed and it's not routinely dealt with. And anything that's not routine is going to be somewhat fraught with difficulty because presumably those adjudicators dealing with the matter and those administrators processing the matter are not going to be overly familiar with that type of travel document, notwithstanding the fact that it does indeed exist. An SB-1 visa, basically the adjudication is going to go ahead and, in a way, it's a pre-adjudication of one's residence and residential intentions. So basically they're going to look at the case and say, did this individual ever did their intent to return to the United States ever break? And moreover, did the circumstances surrounding their being overseas, was it, for lack of a better term, did it comport with the notion that they always intended to return and just for whatever reason couldn't? Or that's one part of the adjudication. And is it clearly factually the case that that individual was just kept abroad due to problems not of their making, and that they always maintained an intent to return to the U.S. In a sense, there's like an adjudication regarding domiciliary intent going on here. And as a result of that, the adjudicator is going to go ahead and look at the situation and circumstances involved in one of these cases in the matters that I've dealt with involving SB-1 returning resident cases, in most of them, the individuals involved either themselves became rather gravely ill and were kept abroad due to that, or someone in their family or closely related to them became rather gravely ill, and it just simply required them to have to remain and sort of let their in both of the cases involving illness, a green card went ahead and lapsed, and an adjudication needed to be made to return to the United States. Once the SB-1 is issued, again, it sort of pre-adjudicates all of these presumptions of abandonment of residence and things like this. And because of that, I guess it's theoretically possible that U.S. CBP can use their plenary power to, make a decision going the other way. That's very rarely going to happen. Again, later officers within the U.S. government are going to respect the adjudication made by the Department of State officials with respect to that individual's intention to return and that individual's lawful permanent residence.